Okay, people, I said I would do this, right? I'm sitting here and I'm like, today, all day, throughout the day, off and on, I'm like, gee, John, I'm sure glad you believed in me all these years. That's what I've been telling myself all day. Because that's one thing he did, people. He sure did believe in me. He was a main factor with me founding the nonprofit and writing and reaching out to the MLAs and pushing that envelope, right? So anyway, as I'm doing this, I hear him telling me, like, you're doing a good job. I believe in you. That's what he's telling me. I can hear him telling me that. So what I'm going to do, though, I'm going to read this to you guys. This is one paragraph. And then I'm going to show you my office. I kind of want to spread out. I need more room. So, you ready? This is number 3. In consideration to Section 7, standards to be maintained under the Community Care and Assisted Living Act, it is the responsibility of Fraser Health Authority to ensure that their agents and various employees are persons of good character who meet the standards for employees specified in their regulations, in addition to operate the community care facility in a manner that promotes the health, safety, and dignity of Mr. Duncan, and including making his rights both orally and in writing known to him and to his legal representative while in the care of FHA. Consequently, FHA, which is Fraser Health Authority, agents breached these basic legislated principles as they continued to retaliate spitefully against Mr. Duncan's representative, the plaintiff, to whom had legal enduring power of attorney. And then I put the sections there. Consequently, this matter regarding enduring power of attorney being revoked in any correct manner that would be considered legal has not occurred in any court of law or been done through the public guardian and trustee, nor has any application been put forward by a legitimate source that would have lawfully removed the plaintiff from her position as the attorney to Mr. John Duncan. In reference to Section 32, immunity, 1, subject to subsection 2, no legal proceedings for damages, lies, or may be commenced or maintained against the director of licensing, the registrar, a medical health officer, or a member of the board, or a person acting on behalf or under the direction of any of them because of anything done or admitted. So in that context, from the way I'm reading it, they're singling out the individual. Okay, these are individuals. You can't go after, the board director that sits on the health authority in order what happened to Uncle John. You can't go after a specific person. They're giving individual immunity to these people that work within the system. That's why people think they can get away with shit. Right? Because they know that they got immunity. Right? The government union will protect them. That's what Uncle John used to say. It didn't matter. Didn't matter if some of these guys worked or not. The union would still protect them. So, you'd end up working for your coworker just to make sure the job got done. And then so on and so on and so on, right? So, if they're doing dirty shit, right, chances are the union's going to protect them. Anyway, 2, subsection 1, does not apply to a person referred to in that subsection in relation to anything done or admitted by that person in bad faith. 3, subsection 2 does not absolve the government, a health authority, or an employer from vicarious liability. And vicarious means delegated authority. In other words, Fraser Health Authority is the licensee. who becomes responsible, arising out of anything done or admitted by a person referred to in that subsection for which the government, health authority, or employer would be vicariously liable if this section were not in force, which I just read. And there's more. In reference to Section 33, offense and penalty, a person who contravenes Section 5.6.18.2, I'm pretty sure that's what that one was, 18.2, 32, just hold on a minute here. Okay. Because there's another section in here, people. And it falls under the Hospital Act. And it falls under the Community Care Living Regulations, the Community Care Regulations. So I got to make sure this reads correctly, so I don't confuse the court. Community Care and Assisted Living Act, that's not the one we want. We want the Residential Care Regulations under section... I have it typed out here, I'm pretty sure. Well, I have the Hospital Act. The Hospital Act, conflict of interest prohibited, and the one, I don't know which section it is. Can't find it right now. Obviously, I'm tired. You can see that, right? It specifically says, right here, this is under the Hospital Act, which would go in line of what I just was saying down here. So I might have to backtrack on this. But I'll read you the Hospital Act. Under Section 4.12, okay, an employee must not do any of the following: persuade or induce or attempt to persuade or induce a patient to make or change a patient's will. Well, I think that's what was happening at the Yale Road Center. I think they were already rewriting his will. Make gift. Well, somebody was getting something out of that. Provide a benefit for an employee or the employee's spouse. The benefit for the employee, which would be Fraser Health in that case, would be that John would be going into long-term care and they'd be making their subsidized, don't have to take taxpayers' money to pay for those old folks' homes because the patient's paying for it, right? So, I mean, it's an automatic default that, you know, the more people that they get paying for those situations, you know, the better it is for the provincial government, right? Provide a benefit for an employee or the employee's spouse, relative, or friend. Definitely a friend. There's definitely nepotism going on in there, and there was definitely, you know, union seniority, and, you know, oh, we're friends, you know, we're co-workers, you know, we're signed up with the same nurses union, you know, it's just a big high five, and we'll go for a drink after work, and, yeah, you know, like, most definitely, people. Or... this is 4 on A. Conduct the financial affairs of the patient for the benefit of an employee. Well, we already talked about that. Or the employee's spouse, relative, or friend. And that's exactly what those social workers were doing. They took on John's affairs. They appointed themselves representative to John's will and his everything. His everything, people. Those social workers removed 35 years of his life out of his brain. .13, a provision of a will, change to a will. John's original will is here. It's been unaltered since 1998 because that's all he needed, people. And if anything else has been written before then, I'm sorry, anything else has been written after that date, from the time John was medically kidnapped, from the time John disappeared, from February 21st, more than likely in a hammock, passed out. It's been manufactured. It's been rewritten for the purpose of fraud. A provision of a will, a change to a will, a gift, a provision of a benefit, or another measure described in subsection 2A1 to 4 is void if it confers a benefit on an employee or the employee's spouse. There's that friend, relative, and this is very important, people. This is B. The public guardian and trustee has not given written consent to it. Because normally it's the public guardian and trustee that does this kind of stuff. In terms of, they will take over somebody's assets, accuse the caregivers of the person of the assets that they took of some form of elderly abuse, and then proceed to go to court with the family members. Normally the family members will go after the public guardian and trustee to regain back their power of attorney. And they have to do it in a court setting because it says so in everything that I'm reading. That's what these things are for. These acts and rules and regulations, and the Guardianship Act and the Hospital Insurance Act, the Power of Attorney Act, the Mental Health Act, the Community Assisted Living Act, and so on and so on and so on and so on. And then 414. I know these are not paragraphs, but this is my paragraph, people. I'm actually reading another paragraph. I went on to the paragraph too. I didn't read the whole paragraph. I'm just reading you the section, and I typed out the section again for easy reading. You don't have to go look it up. It's right there. If an employee acts as an attorney, which those social workers did, people, or a representative, which those social workers did, people, contrary to subsection 2C, the power of attorney or representation agreement and any disposition made under the power of attorney or representation agreement is void unless the employee is a child, parent, or spouse of the patient or former patient. So no matter what these social workers think that they fucking did, they were not his child, they were not his spouse, and they sure in the hell weren't his parent. Fraser Health Authority has to take responsibility for that. Because with those people carrying on like they did with the team, right? Because that agenda went a little further, Nepotism goes a long way, right? And everybody's your friend when you have money, right? It's when you don't have money like me that nobody likes you, right? Because you're poor, right? So somebody was rolling around in money. Because, seriously, people, if John had no money, John would be home right now. With his little will, that's all he needed. And his family. Right? Because he wasn't alone. Like he said, he was not alone. And that's what was important to him. So I think I have to fix something there because I jumped. I went from 3 up to 2? Or was it 3 down to 4? But it's quite long. Oh yes, I was going to show you this. You can see. See, this is legit, people. You can see. I'm not faking the funk here. You can see. 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 You can see what I'm doing here. I'm reading. You can see what I'm doing here, people. I'm reading. I'm reading. No wonder why I can never remember dates. I almost forgot what date it was. Do you see? This is my appeal. I'm already past my 5 paragraphs. And I'm only on to paragraph 4. Okay, people. Yeah, we know I smoke. I'm sitting here, I'm just looking at this here, right? Did I even finish reading this thing to you? I was just bouncing around, right? And my ears are just ringing. Just all day. I go to sleep, man. I lay there and it just squealing, people, squealing. And then just before I wake up, I have like just like a few moments of silence. And then as soon as I start waking up, it just starts squealing. I swear it's pain. I think a lot of it is pain related to do with these teeth. I don't know. But I don't think I finished reading the immunity part here, right? Subsection 1 does not apply to a person referred to in that subsection in relation to anything done or admitted by that person in bad faith. Subsection 1 does not absolve the government, a health authority, or an employer from vicarious liability arising out of anything done or admitted by a person referred to in that subsection for which the government, health authority, or employer would be vicariously liable if that section were not in force. In reference to Section 33, Offenses and Penalty, a person who contravenes Section 5, 6, 18, 2, 3, and 26(1) of this Act, or on a term of condition attached to a license commits an offense. And this is where it jumps, right? In terms of employees are not supposed to appoint themselves power of attorney or representatives, right? A person who commits an offense under subsection 1 is liable for a fine up to $10,000. An offense under subsection 1 is of a continuing nature. Each day that the offense continues constitutes a separate offense. In conclusion to Section 7, standards to be maintained under the Community Care and Assisted Living Act, Fraser Health Authority had a duty of care to provide Mr. Duncan and his legal representative, the plaintiff Judy Chorney, a level of professionalism that was equal to the legislation that governs that duty of care. However, through convoluted acts from FHA agents to defame and slander the plaintiff under false accusations for the purpose to commit fraud on an employee level, where the unlawful seizure of the plaintiff's privilege as legal enduring power of attorney was wrongfully removed from her without due process, clearly shows the negligence of Fraser Health Authority as a ruling body to their employees, as it was the employees as a group who conspired to take over Mr. Duncan's assets at the expense of completely removing him from his immediate family via those convoluted occurrences that has brought this notice of claim forward. That's one paragraph. And I know Uncle John would say, "You're doing good." And he would tell me to keep at it. And he would tell me I can do it. I think that's the big one. I know he would tell me I can do it. And I told my son just a couple days ago, 4 or 5 days ago, honest to God, if I wouldn't have done that nonprofit, people, I don't think I'd be able to do this today. I think the nonprofit was the primer for this. I do. Okay, people, just to show you that I'm working on this, okay? Right? Maybe I should move this camera over here so if it starts flashing, I can see it. Just hold on a minute. Okay, so if it starts flashing, I know I look like crap, whatever. It's going on like 1:30 in the morning now, right? You know, days are rough. I've been having it like really, really, really rough, people. I'm going to be at this tomorrow for 5 or 6 hours at least straight. That's, in other words, after I'm done, I'm going to go to sleep, and then the minute I get up, I'm pretty much going to be getting up on it, and I'll be on it for about 5 or 6 hours. So, the reason I'm reading this is to show that I'm trying, obviously, right? And, you know, as I'm writing it and reading it and, you know, trying to bring my, trying to bring my paragraph that way versus going that way, right? You know, I personally think I'm doing a pretty good job. I'm very thankful that I worked on a nonprofit all the years that I did. Now that I'm having to do this, I just feel that working on the nonprofit has definitely made this easier. I'm just going to read another. This is number 4. I mean, what they going to do, right? They toss it out, people. Eventually, one day, I'm going to learn how to make PDF files, and it's all going to go up online under a PDF file, right? But for now, you know, I'm probably going to still write, oh, I don't know. I'm on number 4. Like I said, I'd give myself 10. Right? Because, you know, there's other things I have to address, and I haven't really addressed them. But this is what this section is. I'm trying to break them up into sections in my head, and then I'm trying to put the section on the paper with the different acts that go within that section. Right? They used law. They use court cases to throw it out. I'm using law to keep it there. So, here we go. In FAA's defense, it has been said that Mr. Duncan was released from the Yale Road Center as if he was a fully functional adult male, to where Fraser Health Authority has absolved themselves from any responsibility as to what has happened to him since being released from their care. However, FHA is not being forthright to the true nature around how Mr. Duncan was being illegally detained, as pain medications were being used against his persons as a restraint method to keep him wheelchair bound for the purpose so that mail fraud could occur in the effort to gain Mr. Duncan's banking information, as the plaintiff was beginning to be accused of elderly abuse by FHA agents to stall for time. Go back into my videos, people. You will see that story all unfold. Because that's what they were doing. That's what they've been doing. FHA agents, contrary to their mandate, conspired with Mr. Duncan's extended family in Victoria, BC, to whom Mr. Duncan had no real relationship with, except for him seeing his extended family members once a year for a 1 to 2 day period, where he would visit his mother in Victoria for her annual birthday party. And it should be noted that as Mr. Duncan aged, he required assistance from his grandchildren within his immediate family to make that annual trip to and from Victoria each year, as he was legally blind and suffered from leg injuries in combination to back injuries from when he was younger. Therefore, it would have been medically negligent for FHA agents to discharge Mr. Duncan from their community care facility without ensuring that proper identification for off-site transfer of his persons was done in a manner that complied with the residential care regulations of the Community Care and Assisted Living Act. Under Section 58, release or removal of persons in care. 1. A licensee must ensure that a person in care is not released from the community care facility to or removed from the community care facility by any person except the person in care's parent or representative or a person authorized in writing by that person. 2. Subsection 1 does not apply to the release or removal of a person in care in accordance with the care plan of the person in care or another pre-existing arrangement. Hence, under no circumstances would Mr. Duncan been able to write a letter authorizing any other person to be his representative for the purpose to remove him from the community care facility without having identification upon leaving the facilities, or for him to refuse any follow-up on any medications that he had been receiving since coming into care of Fraser Health Authority. In addition to, if a third party drafted such a letter in writing and Mr. Duncan signed it, that would have been done under false pretense as listed under the Criminal Code of Canada, Section 3621A and C, due to Mr. Duncan's blindness, as he would have not been able to read what he was signing even if he would have wanted to. Therefore, Fraser Health Authority discharged a 75-year-old blind man who could barely walk without any personal identification on his persons, despite FHA agents having a vendetta to have Mr. Duncan go into convalescent care within the first week of being at the Surrey Memorial Hospital. So in other words, he had a care plan. Remember, I was going to take it to court. I told him to bill us if they really wanted to put him into convalescent care because he doesn't want to go. And he said, put your feet to the grind and fight it. No, that's what he said. No, fight. Don't pay, fight. Take it to court, tell him no, tell him I want to come home. It's the very beginning of those videos, people. Like, seriously, man. Like, how many fucking times do you have to say it? Therefore, Fraser Health Authority discharged a 75-year-old blind man who could barely walk without any personal identification because all his ID was at home on his persons, despite FHA agents having a vendetta to have Mr. Duncan go into convalescent care within the first week before his lung infection had even been cleared up of having a vendetta to have Mr. Duncan go into convalescent care within the first week of being at the Surrey Memorial Hospital. Again, his lung infection wasn't even cleared up. Who has power of attorney? Well, I do. Well, sign here. Why? Let me talk to John first. Let me see how he's doing. What's wrong with John? Well, it doesn't matter what's wrong with him. He's going into convalescent care because the team wants him there right now. So sign right now, right now, right now. And I'm like, whoa, maybe you need to remove yourself from the file. Well, instead, this bitch wanted to remove his family from the file. And now I'm having to fight to put us back on the file. A file that they don't even have anymore, people. They have to go find that file.